Honourable Senators, it's a touch poetic that these walls, once privy to the negotiations to patriate the Canadian Constitution, will once again hear debate to restrict one of the defining compromises that brought that repatriation to life. This Senate of Canada building was once the Government Conference Centre, where political stalwarts gathered to discuss a plethora of ideas spearheaded by the federal government of Pierre Elliott Trudeau. The Patriation Package, as it's known, transferred the British North America Act, renamed the Constitution Act, 1867, the nation's highest law, from the authority of the British Parliament. Beyond removing the grasp of British institutions on our national dealings, the package sought to introduce amendment formula to alter the Constitution here at home. But no idea was larger or more influential than the Canadian Charter of Rights and Freedoms, and no compromise was discussed in greater detail than the acceptance of Section 33 of the Charter, known as the Notwithstanding Clause. The compromise? The federal government would get their constitutional package, forever changing our rights landscape in Canada, and the provinces who asked for the Notwithstanding Clause would ensure their legislative supremacy over courts where there was seen to be an important conflict of rights. For the purposes of my remarks, I will use the term Notwithstanding Clause, Section 33, and override interchangeably. Prime Minister Pierre Trudeau found no joy by including the Notwithstanding Clause and made it clear during and after the patriation of the Charter. Jean Chrétien, Attorney General at the time, wrote in his book, My Story, My Times, that, quote, after 1982, whenever I met Pierre Elliott Trudeau, he rarely missed an opportunity to express his frustration at having been forced to accept Section 33, close quote. Now, why was this? Well, to Trudeau, he regretted that the Charter was not fully entrenched because governments could still diminish rights by using the Notwithstanding Clause. Yet it is precisely because of this compromise that we have the Charter today. Those who attended the constitutional discussions agree that without Section 33, there would have been no Charter. Now, compromise is a cornerstone of a functional democracy. Voters may choose and may compromise their choice in elected representatives for what they view to be a greater benefit. Governments may compromise to pass platform commitments, especially minority governments. Even we as senators have compromised to move business forward or to simply agree on a committee report. It's a notable and notifiable way to ensure that viewpoints encompass all that we hear. But compromise can be tricky, as evidenced by the constitutional negotiations of the early 80s. It can also be hard work. It has become apparent to me that increasingly populist governments would rather avoid compromise when it comes to the Charter of Rights of Canadians by invoking the Notwithstanding Clause. Oftentimes, it has done it preemptively, going against all intentions of the provincial representatives who originally fought for it. This is summed up brilliantly by Thomas Axworthy when he stated, and I quote, "Today, with polarization and partisanship expanding exponentially, compromise seems to be out of favor when compared to the delights of single-issue fervor," close quote. Politics have turned into a blood sport. The rhetoric and histrionics used by political parties, some more than others, seek to divide and create an us versus them mentality. Where the party goes, the base blindly follows, and facts, logic, and reason hold no persuasion. Compromise becomes futile because there is no talking with the perceived enemy. Not everyone encourages or follows this approach, but there's enough of it to be damaging to our political institutions. While it has been the provinces who have engaged in what I would call misuses of the Notwithstanding Clause, the then leader of the opposition, Pierre Poilievre, not so subtly hinted at its use for certain criminal justice reforms in remarks he gave to the Canadian Police Association in April of 2024. And again this year, on April 15th, during the campaign, Mr. Poilievre went further and explicitly stated that a Conservative government's intention to invoke the clause the Notwithstanding Clause, that is, for consecutive sentencing. This is an example of that single-issue fervor noted by Mr. Axworthy. At the time of the CPA speech, it seemed a Conservative majority government was a sure thing, which surely played into the calculus of the then party leader. The notwithstanding clause has never been used federally, and Mr. Poilievre's announcement worried me a great deal. The notwithstanding clause has laid in abeyance for 43 years, and yet no Prime Minister has clarified a federal government's position on its use. It has now taken the threat of a federal provocation for Parliament to wake up and to consider how best to deal with such a case, should it appear, and that includes us in the Senate. How do we rationalize its use when considering our constitutional duties in this chamber? Stemming from the motion I introduced last spring, I've decided to turn that discussion into action. For those who weren't here at the time or don't remember my motion, it called on the Senate to express the view that it should not adopt any bill containing a declaration pursuant to Section 33 of the Charter of Rights and Freedoms, commonly known, as I say earlier, the Notwithstanding Clause. I would encourage you to read my speech, but more importantly, those of Senators Ringett, Cotter, and Simons, who also participated in this debate. For what it's worth, my speech to that motion provides the context as to why I introduced Bill S-218. The wording of the motion was meant to be provocative, to inspire discussion and debate. Similarly, you will find that Bill S-218 is equally, if not more, provocative. It seeks to amend our Constitution. Could this have been a standalone bill? Of course it could. However, I didn't pursue a standalone bill for a couple of reasons. First, seeking to alter how the federal government approaches fundamental rights and freedoms in this country, especially ones of this magnitude, should be advanced in an equally serious way. Second, a constitutional amendment attracts prominence. The point is to be provocative, ensuring robust debate and study on something consequential. A standalone piece of legislation restricting the use of Section 33 is constitutional amendment adjacent. I want to be direct in stating that the intention is to amend the Constitution, not to appear to be doing so from a distance. Amending the Constitution isn't easy because of the constitutional amending formula attributed at the same time as our Charter. However, the amending formula under Section 44, dealing with federal unilateral amendments to the Constitution, may well be of service. Our former colleague, Senator Cotter, acknowledged this could be the case when speaking to my motion. I would hope that Senator Gold has a similar reading, and I look forward to his participation in this debate. As a reminder to others, Section 44 unilateral amending formula reads as follows under the heading Amendments by Parliament, subject to Sections 41 and 42. That is, the amendment by unanimous consent formula and the amendment by general procedure. Parliament may exclusively make laws amending the Constitution in relation to the Executive, Government of Canada, or the Senate and the House of Commons. This formula is one of the most easily achievable and has been used in the past to increase seats in the House of Commons and to provide representation to Nunavut here in the Senate after its formation in 1999. Bill S-218 is a more creative use of this amending formula, though one that I believe captures its nature. It does not disturb other amending formula, nor the underlying architecture of the Constitution as described by the Supreme Court's in its reference on Senate reform in 2014. This is a relatively simple amendment to a federal use of Section S of the federal section. Bill S-218 is entitled An Act to Amend the Constitution Act 1982, Notwithstanding Clause, and amends the Constitution to insert after Section 33(1) after Section 33, which deals with the override. The first provision of this bill, 33.1 sub 1, falls under the heading Application. This makes it very clear that the bill affects only the federal parliament and leaves the provinces out. Provincial inclusion would require a different amending formula with necessary consultation. This isn't viable as a Senate public bill. Senators may notice that the wording of this provision is taken almost verbatim from Section 32 sub 1 sub A of the Charter, which speaks to the application of the Charter as a whole. This ensures continuity with the wording of that section while confirming its inapplicability to the provinces. The next section, 33.1 sub 2, introduces terminology for the purposes of this bill. The first is declaration, referring to a notwithstanding clause declaration made under Section 33 of the Charter that any act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Sections 7 to 15 of the Charter. These sections pertain to our fundamental rights and freedoms, legal rights and equality rights. The second term is infringing bill. An infringing bill refers to any bill containing a declaration. These terms are found within the bill, and it's helpful to understand their meaning. 33.1 sub 3 is simple. It delineates that an infringement bill must be introduced by a minister of the House of Commons, while the government may, in some instances, opt to initiate the legislative process for their bill in the Senate for efficiency or to get a sense of where the Senate is on a particular bill. Under this paragraph of Bill S-218, an infringement bill must begin in the House of Commons, much like an appropriations or tax bill. I decided to approach an infringing bill in this way because the current protections built into the Charter of Rights and Freedoms regarding a use of the notwithstanding clause and the compromise made between the federal governments and provinces to ensure its patriation require an informed and engaged electorate to keep government's feet to the fire. This is found under current sections 33.3 and 33.5 of the Charter, imposing a 5-year sunset clause on the use of the notwithstanding clause and a requirement to reenact a declaration for its continuance. Five years would normally encapsulate an election period, and this would ensure that the electorate had the ability to toss out the government should they discover rights violations stemming from the use of an override to be a final straw. I argued in my motion speech that I don't feel this is protection enough against rights violations. It is also for this reason that an infringing bill must begin in the House of Commons with elected representatives. We are not elected, and therefore the illegitimate starting point for such a debate. The next provision deals with prior rulings. This is an exceptionally important part of Bill S-218 because it removes a federal government's ability to preemptively use the notwithstanding clause. The preemptive use is at the root of recent provincial abuses and has offered telling conclusions as to why it should be removed altogether federally. The compromise to incorporate the clause in the Charter never included the invocation of the clause prior to the judiciary having their say. During Doug Ford's first intended preemptive use of the notwithstanding clause in 2018 to reduce the size of Toronto City Council, Jean Chrétien, Roy Romano, and Roy McMurtry came out against its use and said it was against the spirit of the compromise, which is very important because these are the three so-called kitchen cabinet who thought up the notwithstanding clause compromise, which made patriation successful. For the purposes of this bill, there are two avenues ensuring the judiciary has had their say. The first is if the Supreme Court has referred a bill or a provision thereof under Section 53 of the Supreme Court Act and has found that bill or provision to be unconstitutional. The second is by the usual process of an outside party challenging the constitutionality of a law or a provision thereof and having itself work up to the Supreme Court as the court of final appeal and then finds it to be unconstitutional. Either way, unconstitutionality would have to be in relation to Sections 2 or 7 to 15 of the Charter as a proper invocation of Section 33 currently dictates. Should our highest court find unconstitutionality, the minister could then introduce an infringing bill, but the language of the bill would have to match that of the court-tested unconstitutionality provisions. If the language changes from what has already been tested, it could nullify the process of an infringing bill. We all know that when drafting laws, language matters. Further to this, as Sujit Choudhury and George Anderson wrote for a symposium honoring Peter Hogg, quote, prohibiting the preemptive use increases the political costs and reduces the likelihood of its use by forcing governments to confront a judgment finding a law unconstitutional, close quote. It adds to proper discourse between the courts and the executive and legislative branches as originally intended. The next four provisions of Bill S-218 attempt to guarantee that there is proper public disclosure and awareness as to what the rights violations are and the government's rationale for pursuing a notwithstanding override in an infringing bill. The first includes a preamble within an infringing bill incorporating the reasons for the declaration. Preambles are common course in legislative drafting. The next provision, 33.1 sub 6, requires that a charter statement be tabled with the infringing bill speaking to the potential effects on the rights under Section 2 and Section 7 to 15, along with the reasons why an infringement of those rights can't be justified using Section 1 of the Charter alone. This section allows governments to infringe charter rights subject to reasonable limits prescribed by law. The government must detail why it chose to invoke the notwithstanding clause rather than utilize the well-known test for complying with Section 1. As stated by Senator Cotter during his speech last Halloween, the notwithstanding clause preemptively delegitimizes many rights and implicitly the value of Section 1, the rights limiting clause, and the jurisprudence of the Supreme Court of Canada in crafting a sophisticated approach to Section 1. The government should have to explain its position in advance. The subsequent provision falls under the heading of time allocation. Simply, it removes the ability to curtail debate on an infringing bill. It applies to both the House of Commons and the Senate. It is vital to ensure that such important matters be considered fully before any potential vote occurs. 33.1 sub 8 of the bill is similar to that of the previous provision, but relates to committees of the whole in both chambers. Should an infringing bill receive a positive vote moving to committee stage, a committee of the whole cannot be used to expedite study. Committee study is the most important work MPs and senators undertake, and this is where in-depth analysis takes place and expert opinions are heard. We use the information to supplement our thinking as lawmakers and to offer potential solutions or compromises. Eliminating the committee process on such a fundamental issue as charter rights is neglectful and uncaring, especially for minority populations who are most frequently at the wrong end of abuse cases. These four provisions will, I hope, work to better inform Canadians of legislation that fundamentally affects their constitutional rights, so that the so-called 5-year sunset already found within the Charter can operate as intended. The notwithstanding clause is meant to check the courts, and the people are meant to check the government. But what checks an uninformed populace? If Canadians aren't aware that their rights are being abused, the 5-year sunset clause is impotent. Populist governments will take the easy path to achieve their ends, as we have seen provincially. Guardrails are needed. The final provisions should change voting requirements in the House of Commons. Under this proposal, any motion to read an infringing bill for the third time will require a supermajority of 66% of the votes in the House of Commons from the entire membership, that is 227 votes in favor out of 343. Further, should a majority government have more than 227 seats, there is a requirement that another recognized party support the infringing bill. This would only apply in the House of Commons, not the Senate. The elected chamber should have the weightier decision-making duty. The Senate will contemplate the same in due course, but with consideration to the decision of the elected chamber. This is an accountability and transparency measure that I hope the chamber would agree with. Make no mistake, these proposed amendments intend to make a federal invocation of Section 33 more difficult, but not impossible. I believe these amendments run parallel to the original intention of the drafters of this clause more than 4 decades ago. In 2025, this is even more important than ever. Canadians today often don't understand charter rights or what they mean and are largely ignorant of the notwithstanding clause. This can be explained by the simple passage of time, as well as the clause's relative disuse since 2018. But it's also because of the way many Canadians receive information and distrust institutions and authority figures generally. Informed Canadians, properly informing Canadians of their rights and what an override may do to them is the very purpose of this bill. Let's remove the shortcuts, slow the process down, and ensure that Canadians know what's at stake for a federal abuse of Section 33. This is why a full judicial appeal process be standard before the introduction of an infringing bill, and why unfettered debate should be encouraged. If a government wants to override our rights, it should explain itself by meeting these criteria. Colleagues, these conditions are not all my own. I spoke to the Peter Lougheed principal during my motion speech. Lougheed, the Premier of Alberta at the time of the constitutional negotiations, along with Sterling Lyon and Alan Blakeney of Saskatchewan, were adamant defenders of the idea of the notwithstanding clause. Lougheed spoke to the notwithstanding clause and its inclusion in the Charter at the University of Calgary in a very famous lecture in 1991, and I would wish to quote from it, where he says, "The purpose of the override is to provide an opportunity for the responsible and accountable public discussions of rights issues, and this might be undermined if legislators are free to use the override without open discussion and deliberation of its specific use." There is little doubt that when defying the Supreme Court, as well as overriding a pronounced right, a legislature should consider the importance of the right involved, the objective of the stricken legislation, the availability of other, less intrusive means of reaching the same policy objective, and a host of other issues. It should not be the responsibility of the court, said Lougheed, to determine whether a limit is reasonable or demonstrably justifiable in a free and democratic society, end quote. So having witnessed the uses of the notwithstanding clause in Quebec, which applied it writ large to their laws in protest of being the only province not to sign the Charter, and in Saskatchewan, which used it preemptively in labor negotiations bill, Lougheed concluded that the original purpose of the clause wasn't being respected, nor was it providing an opportunity for responsible and accountable public discussion of rights issues. After 9 years of thinking about the notwithstanding clause, Lougheed, in this very same lecture, proposed 3 amendments to the section. The first is that Parliament, or a legislature, be required to spell out the purpose of any legislation disallowing standard form rights override of rights. This was proposed in the 1985 Royal Commission on Economic Union and Development Prospects for Canada, as known as the Macdonald Royal Commission. And the Commission's recommendation reads as follows. The Charter's general override provisions should contribute to public awareness of legislation limiting the constitutional rights of citizens in Canada. Overriding legislation should include a declaration of intent to legislate, notwithstanding a provision of the Charter, and should include not only a reference to the specific rights being overridden, but also an indication of the purpose of such legislative action. Such a statement would help courts to ensure that limitations do not exceed what is necessary to achieve the objective. It could also be a useful reference point in discussions on whether to extend the override after the 5-year period, ending the quote from the Commission. This approach is covered to some extent in Bill S-218. The second Lougheed Amendment would require a supermajority of 60%. He argues that invoking the notwithstanding clause is too substantive an action by an elected body and requires a higher level of authorization than a simple majority. This is consistent with a 1991 proposal paper offered by the Government of Canada entitled Shaping Canada's Future Together, which proposed a 60% supermajority. I agree and have insisted instead on my 2/3 majority consisting of two recognized parties, ensuring dialogue and compromise. Lougheed's last amendment proposal ensures the notwithstanding clause is never invoked preemptively. He states, and again I quote, "In my mind, such an action is undemocratic in that the purpose of Section 33 was ultimately supremacy of Parliament, of the judiciary, not domination over or exclusion of the judiciary's role in interpreting the relevant sections of the Charter of Rights." Close quote. He anticipated that all rights of appeal be exhausted before an invocation, which you would find in the prior ruling subheading 218, though I have proposed that a reference to the Supreme Court would also be action-provoking. I have tried to incorporate Lougheed's principles into my own bill because I believe, as he did, that they are pragmatic amendments preventing the abusive nature of Section 33. Some of Canada's major law associations have called for versions of Lougheed's proposal to safeguard or limit the use of the notwithstanding clause. In a letter entitled "Establishing Guidelines Concerning the Use of the Notwithstanding Clause" to then Minister of Justice and Attorney General Arif Virani, the Canadian Bar Association proposed 4 guidelines, which include 1, barring the preemptive use of Section 33, 2, requiring a 2/3 majority in the legislature or parliament, 3, a requirement of meaningful and transparent public consultations before invocation, and 4, preambular statements as to why it has been considered necessary to invoke the clause. These proposed guidelines are all found in Bill S-218. In December 2024, the Canadian Civil Liberties Association also wrote to then Prime Minister Justin Trudeau, entitled "Misuses of the Notwithstanding Clause are a Threat to Our Charter." The CCLA recommends 3 limitations, 2 of which we know well: disallowing preemptive use of the clause and a supermajority requirement when voting. This builds on their Save Our Charter campaign, which can be found on their website, and speak to the damages of recent uses at the provincial level. The third limitation in their letter would allow courts to review uses of the notwithstanding clause. This, in my opinion, may be a bridge too far, considering the original purpose of the inclusion of Section 33 by the provinces. If public consultation is part and parcel of the notwithstanding clause process, this should suffice in allaying fears of its misuse. Put another way, if the populace is determined to be the final arbiter of rights issues, let them be informed of the trade-offs before the federal executive can ascertain the ability to invoke. A question can be asked here: how is it possible to legislate these guidelines when we are not able to legislate in a restrictive way for future governments? I would say there's a difference between legislating substantive issues and legislating procedural requirements. Bill S-218 does the latter. It places self-imposed procedural restraints on the enactment of federal bills invoking the notwithstanding clause. These are also known as manner and form requirements. Professor Craig Scott with Osgoode Hall Law School stated manner and form requirements are, quote, statutory requirements that one legislature seeks to impose on future legislatures in the form of either inhibitory conditions or preconditions or facilitative permissions for the enactment, amendment, or repeal of statutes or provisions within statutes, close quote. The manner and form requirement of S-218 would be an inhibitory precondition for the enactment of laws containing the notwithstanding clause. While 218 legislates in a restrictive way by implementing a manner and form requirement, it does not withhold the ability of federal governments to invoke the notwithstanding clause, nor are these amendments immune from a repeal. They would be difficult to repeal, however, based on these grounds and on what is being protected. One of Canada's foremost constitutional experts, the late Peter Hogg, was confident that manner and form amendments are appropriate in Canada's legal structure. Coming from his authoritative constitutional text, Constitutional Law in Canada, he wrote, and I quote, "While a legislative body is not bound by self-imposed restraints as to the content, substance, or policy of its enactments, it is reasonably clear that a legislative body may be found bound by self-imposed procedural or manner and form restraints on its enactments, close quote. He then wrote, and I quote again, would the Parliament or legislature be bound by self-imposed rule as the manner and form in which statutes were to be enacted? The answer, in my view, is yes, close quote. If S-218 makes its way through Parliament to receive royal assent, it would be a self-imposed law. Parliament would have agreed to the restrictions it's placed on itself. Manner and form restrictions aren't without precedent. For example, provinces abolished their upper houses using only normal legislation, making them unicameral. This is manner and form legislation. Parliament or legislatures could add another element to their legislative process for all laws or particular kinds, as long as their ability to do so isn't usurped by a constitutional amending formula. Yes, I'm using constitutional amending formula, but the federal unilateral amending formula, not one that requires consultations and the amending formula involving provincial governments. While this bill seeks to make legislation the use of the notwithstanding clause more onerous, both Hogg and Scott bring up the example of Westminster, which used manner and form requirements to make legislating easier. The Parliament Act 1911, British Parliament, was enacted by the Commons and the House of Lords. It provided that a bill could become an act of Parliament without the consent of the Lords if it were passed by the Commons and rejected by the Lords in 3 consecutive sessions of Parliament over a period of at least or not less than 2 years. The Commons then used this manner and form procedure in 1949 without the consent of the Lords to add further leniency to some provisions, increasing the power of the Commons by delaying the Lords' delaying power to 2 sessions and 1 year. The manner and form requirement initially established with the Lords was subsequently used against them. Hogg indicates in his manner and form chapter in the Constitutional Law of Canada that in order for a manner and form provision to be fully effective in law, it must also apply to itself. This being doubly entrenched or self-referencing. Essentially, manner and form must not only apply to the protected category of laws, in this case federal laws that invoke the notwithstanding clause, but it must also apply to laws that seek to amend or repeal the manner and form provision itself. If we were to follow his recommendation, the criteria I have provided allowing for invocation of the notwithstanding clause would also apply to amendments to or repealing of this bill. I decided against the double entrenching of this provision, and I'm glad to see Senator Gold is nodding his head in approval. The fact that a constitutional amendment is being sought should be enough to deter future governments from trying to repeal it altogether. It would be a winning strategy to attempt to reduce those rights we're trying to protect through 218 through outright appeal. It is by amending the Constitution that the manner and form requirements gain credence. In amending the Constitution for these purposes, it too will form part of our supreme law. A standalone bill attempting to do the same wouldn't have the same gravitas or deter abuses. It's another reason why I felt it appropriate to amend the Constitution itself rather than taking an outside looking in method of a standalone bill. Taking the arduous path here is the right approach. It displays the federal government's leadership and the importance it places on protecting fundamental rights. If the federal government implements restrictions on the use of the override through constitutional amendment, perhaps the provinces will be inspired to do the same. My hope is that provinces will see the benefits of being self-limiting and reduce the tyranny of the majority in its use. An argument could be made that the notwithstanding clause has fallen into disuse since it has not been used federally in 43 years. As a result, restricting its use is easier for the federal government than for the provinces. As such, a constitutional convention of disuse may now exist. This is an opinion also shared by Senator Cotter, who, in the same speech I referenced earlier, said, "We have matured as a nation with the assistance of the Supreme Court of Canada and its own articulation of rights and their limitations. We have matured in our understanding of basic rights and their boundaries to the extent that parliamentary inference and to negate those rights is no longer needed. Hence, a convention, or at least with respect to Parliament, that the notwithstanding clause is inoperative. So said Senator Cotter. He goes on to say that this maturation has taken us to a place where, as citizens, we recognize that as a matter of principle, that it is no longer wise to preserve parliamentary supremacy in ways that can deny human rights, and we are in an era which the preservation of certain rights, those captured in the Charter, adequately defined and circumscribed, ought not be exposed to the vagaries of parliamentary supremacy. That was my thought process when first hearing then Leader of the Opposition implies intended use of the notwithstanding clause. But this begs the question, what if provinces continue to disobey the spirit of 1982 compromise by continuing use of the clause? When does the federal government step in, or do they at all? An employable tool remains in the federal government, disallowance. Found in Section 90 of our Constitution, disallowance would essentially allow federal cabinet to remove provincial laws from the books. The last use of the disallowance power came in 1943, so it can be argued that a constitutional convention exists in its disuse as well. If a perpetration of right violations exists provincially, could we see a federal government blow the dust off of this provision? It would likely cause joint crises in constitutionalism and federalism, and likely wouldn't be worth the political cost. So calm down. A convention of disuse of Section 33 federally and a convention of the disuse of disallowance should be respected. Two wrongs don't make a right. I introduced 218 with the original drafters of the notwithstanding clause in mind and their commitment to compromise. This bill itself is a compromise. While I'd rather see it completely removed, I'm proposing safeguards instead. They don't block us its use, and they don't disrespect parliamentary supremacy. They do, however, restrict its use federally by ensuring proper conversations occur to inform Canadians, the ultimate arbiters of rights, where their rights stand. While Mr. Poilievre initially hinted at the use of the clause to the CPA, he removed subtlety altogether during the election campaign by stating that he would impose the notwithstanding clause for consecutive sentencing. This is perhaps a not shocking appeal, but keep in mind that this is the first time it has been promised federally. First time it has been promised federally. To borrow an analogy from Benjamin Perrin, Prime Minister Harper's former legal advisor, the notwithstanding clause is part of the Charter like an emergency exit door is part of a plane. You'd better have a very good reason to use it and be prepared to explain yourself if you do, he writes. I note that the use of the clause was nowhere in the written Conservative Party platform. This tells me that Mr. Poilievre cares more about politics than the Constitution, and that an abuse of power is worth reaching for as a means of a political end. He's also following the provincial government by attempting to equate democratic legitimacy with rights abuses. The democratic legitimacy approach is a weak argument, especially when necessary public discourse is all but avoided. Perhaps more disturbing is that the Conservative Party seemingly supports such an abuse of power overall, as Mr. Poilievre's remarks speak to a larger, capital C Conservative policy on justice reforms. While an immediate threat of Section 33's use federally has subsided in the recent election, I would argue that ensuring restrictions prior to a future threat is even more necessary in this Parliament. Political winds shift, and we must be prepared. I ask that we move this bill to committee for study, where we can call upon experts who are eager to participate. Rights determinations were always envisaged to be a dialogue between governments and the courts after the courts have spoken. Removing the courts reduces rights to a monologue, an elected majoritarian soliloquy. It's time to insist on constitutional supremacy. Thank you.
I had Senator Batters and then Senator Husako. Senator Batters, do you have a question?
I do. Senator Harder, in your speech today, you said that the House of Commons, quote, should have the weightier decision-making ability on these types of bills. You also called the Senate unelected and stated it was, quote, therefore an illegitimate starting point, unquote, for such a bill, which uses Section 33 of our Canadian Constitution. So if the Senate, in your words, is an illegitimate starting point for such a bill using a section of our Constitution, then why isn't the Senate also an illegitimate starting point for your bill, which seeks to prevent using a section of our Canadian Constitution?
Senator Harder.
That's a very good question, and I thought of that myself, and I thought we got to start somewhere, and I would have gladly endorsed a bill, a government bill or a bill in the House of Commons. But let's start it here and engage the other house.
Senator Batters.
That's quite an answer. You spent quite a bit of time, both in your speech today and in your previous speech that you made on the motion earlier, talking about the use of the notwithstanding clause by, quote, populist governments. But Saskatchewan's NDP government with Premier Alan Blakeney was actually, if it wouldn't have been for Alan Blakeney, no doubt I'm sure you would concede that we would not have the notwithstanding clause as part of our Constitution. That was his demand to actually get the charter repatriated. So, and as I point out, Premier Alan Blakeney was a Rhodes Scholar and a long-standing constitutional law scholar, yet the notwithstanding clause and the use of it, and not limiting it to provinces, but also having the possibility of it being used by the federal government, was included in the Canadian Constitution as part of that balancing of rights. And I also don't believe that Saskatchewan NDP Premier Alan Blakeney would have called himself a populist ever. Now, in the Charter's earlier years, the Quebec provincial government used the notwithstanding clause preemptively on basically every single time they brought a piece of legislation forward. And so given that, wouldn't you acknowledge that it is not just populist governments who have considered the notwithstanding clause to be the better way to balance rights?
Senator Harder.
Just a point on Premier Blakeney first. You're right, he was a constitutional scholar. He was well-educated, Dalhousie Grad School, I believe. His Attorney General, Mr. Romano, signed the letter to which I referenced earlier, saying it was never their intention to use it preemptively. And that was, I believe, the curse of the use of the notwithstanding clause as was experienced in various provincial jurisdictions. So I think Mr. Blakeney would share his Attorney General's interpretation of the preemptive use. As to my reference to populist governments, you're right, it hasn't been just populist governments, although populist governments have championed it for very specific targeted groups, and we can have that debate. I'm happy to have that debate.
Senator Husakos, Senator McDonald.
Madam Chair. Senator Harder, you rightly point out that if it was not for Section 33 in the notwithstanding clause, there would be the Constitution would not have been repatriated, and there'd be no Charter of Rights. It's actually quite similar to the Charlottetown Conference in 1864, when over half the time was spent deciding on the composition of the Senate and whether or not there would be a Senate. And the argument at the time was basically no Senate, no Canada. So there are compromises made when we're approaching a constitutional issue.
Thank God.
So I will, you mentioned the abusive nature of Section 33. Do you consider the use of Section 33 by the governments of Quebec and Saskatchewan to be an abuse?
Senator Harder.
Let me comment first on your broader point about it was a necessary compromise. Absolutely, I referenced that. And that is why I'm not saying we should abolish the notwithstanding clause, or for the Senate for that matter. But I would note that Meech and Charlottetown corrected. Prime Minister Mulroney was a huge critic of the notwithstanding clause, and his amendments in Charlottetown and Meech were designed to reverse that process and, in a sense, obviate that compromise to provide for a whole new set of of inclusions in the Constitution that would have had, at least had government of Quebec's support. So I think it's important to be clear that federal leadership from Pierre Elliott Trudeau, Mulroney, Mr. Chrétien, Mr. Harper, Mr. Trudeau have all been supportive of not invoking the notwithstanding clause federally. After 43 years, no government of Canada has ever invoked the notwithstanding clause. Now you ask me about provincial invocation of notwithstanding clause. I've made a statement in the House on Bill 21 expressing my concerns about its abuse. But this bill does not deal with the provincial use of the notwithstanding clause and seeks to set a higher standard for its use at the federal level, and hopefully can be a guide and an inspiration to provincial governments and civil society.
So time for debate is expired. So I was wondering if Senator Housakos, did you have another question?
Was wondering if Senator Harder would ask for more time so we can...
Well, Senator Harder, are you asking for more time?
Only if Senator Housakos has questions.
So is leave granted, honourable senators? Senator Housakos.
My question, Senator Harder, is I'm a little bit perplexed because I always thought that this institution's job is to be the custodian of the Charter of Rights in our Constitution. We have provinces, we have elected national assemblies, we have the Parliament of Canada, and we have an amending formula when it comes to amending our Constitution. And this is at the core of our Constitution, our Charter of Rights and Freedom. Wouldn't you think it'd be far more appropriate that this would be left in the elected arena for those who actually have a direct and legitimate right to amend the Constitution and the Charter, and it's not the adequate place is not this place to start such a debate?
Senator Harder.
On the contrary, Senator, I believe that first of all, this is not an amendment of the Constitution that falls within the broader amendment formula. It falls narrowly within the Parliament of Canada prerogatives. And as I indicated, the bill itself gives greater authority or greater weight to the considerations of the House of Commons. But I do believe that a manner and form amendment is quite properly part of the consideration of this chamber, and hopefully we will send it to the other chamber and they will deliberate as well. This is, again, not about the amending formula writ large or the use or abuse of the notwithstanding clause by provinces. It's about how the Parliament of Canada will deal with should an amending formula or should notwithstanding clause bill come to us, the manner and form with which we as a legislative chamber, both the House of Commons and the Senate, would deal with it. And I think it's just good policy hygiene to do so.
Senator Housakos.
Amending, we have a tradition in this place of not even allowing, not infringing upon money bills, but yet here we are infringing upon the Charter of Rights and the Constitution and dictating to a future Prime Minister or current Prime Minister how they can use what is legitimately unconstitutional in the Constitution and the Charter of Rights. I think a lot of people would find that over on the other house, but more importantly, in the Prime Minister's office and those sitting in government, quite offensive.
Senator Harder.
Then let's agree on sending it there for their deliberation and consideration. So let's, as a Senate, deal with this quickly, get it over to the chamber that you referenced, and have them deal with this. Again, the amending of the Constitution that this bill purports is in the manner and form with which Parliament would deal with, should it ever receive one, a bill using the notwithstanding clause. So I think that you're right, and let's get this over to the House of Commons because it would be it'd be worthy of a debate.
Senator Housakos. I'm looking at the clock, so I have to interrupt. And honourable senators, it is as I said, 7 o'clock, and pursuant to Rule 3-31, I am obliged to leave the chair until 8 o'clock, when we will resume, unless it is your wish, honorable senators, to not see the clock. Is it agreed to not see the clock? Agreed. So ordered. I want to just I just want to clarify something. Senator Harder, when you asked for more time, was it to answer Senator Houssakos' question, or were you asking for 5 more minutes?
I'm happy to answer questions from Senator Houssakos, but I'm also happy to have the room have their dinner.
Senator Houssakos.
Senator Harder, I obviously the chamber will indulge your bill, but one thing I think all colleagues will agree, that something of such importance as the Charter of Rights and the Constitution should be indulged, but not quickly. Thoroughly, but not quickly.
Senator Harder.
Government is slow until it's fast. And the Senate certainly abides by that principle. I do hope that we can get it to committee and hear from witnesses, because I think that would inform our collective understanding and perhaps help in a broader public discourse with interested parties. So I'm not by any means suggesting that we rush headlong into this, but that we advance it sufficiently that appropriate study, in depth, in committee, can be part of our early agenda.
Senator Harder, there are 2 more senators that asked to ask questions. Are you asking for more time?
Sure, and I don't even know who they are, so that's it. Absolutely.
So you're asking for more time. Do you agree, senators, to allow another 5 minutes? Agreed. So Senator Batters.
Thank you. Senator Harder, in your bill, when you speak about what would be required for such a, quote, infringing bill to pass the House of Commons, and that would be a bill that includes the notwithstanding clause use, and that requires 2/3 of the membership of the House of Commons, as well as members from at least 2 groups comprised solely of members who are members of the same recognized party. So just to use for an example, so people realize what we're dealing with here and how onerous this is, and frankly, it feels a little bit like it's meant to never happen. The current House of Commons has 343 members now. That would require 228 House of Commons members to vote for this, which means, since they have to come from at least 2 different groups, the only 2 groups that could actually achieve that would be the Liberals and the Conservatives. What I'm wondering is, are you meaning it to be such an onerous step that such a notwithstanding clause use would be meant to never pass?
Senator Harder.
Well, Senator, Peter Lougheed had the idea first, and I would think that as one of the founders of the constitutional argument and indeed the compromise of the notwithstanding clause, we should pay attention to him because of his worry about its abuse. So am I trying to make it more difficult? Absolutely, I'm trying to make it more difficult because we're talking about infringing constitutionally enshrined rights. So yes, let's make it more difficult.
One last question, Senator Harder, and I'm going to show my ignorance. I'm not a lawyer. If some future government decided they wanted to pass something changing the criminal code like you referenced in a bill, which it would have to be a bill, couldn't they just throw in the language to undo what you're proposing be done in the same bill and drive on? Is there any protection that you've wired into this that would actually protect your bill from a simple majority vote sometime in the future in the House of Commons to unwind it? And my worry is, we've seen this with labor law. Unions have to secret ballot, and then it's no, they can come to your house and make you join. Back and forth, back and forth. I think since I've been here, it's been 3 different ways. So is this what we're going to do to the Constitution now, is just have it that every government changes it to, are you worried that could dilute the sanctity of the Constitution as it stands now?
Senator Harder.
Senator, remember, this is a manner and form bill, so it doesn't change the protections of the Charter. It simply entrenches the process by which a bill using the notwithstanding clause has to proceed. Now, I did not entrench the manner and form amendment.
Correct.
And I spoke about that as to why. But a government that was determined to advance a bill in violation of the manner and form that we could have introduced would have to first have a piece of legislation revoking that manner and form before they could advance their piece of legislation. And I'm counting on the intelligent debate of parliamentarians and senators of civil society to engage a government that was proposing to do that in a more serious level of discussion on what are our charter rights and freedoms and what does an infringement of them mean. Because it would be more complex than worthy of the double entrenchment, if I could put it that way, that you alluded to. So I've deliberately decided to go, if I could say, light on manner and form, but it is a constitutional amendment. But I'm not amending the amending formula with the manner and form.